Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
No, I'm not Peyton Ansley John Milton. I am the agent authorized to represent Peyton Ansley John Milton as written in all capital letters.
Thank you. And as to Mr. Milton, is there a competency concern, or is this
I am not represented by anybody besides myself. In my sovereign capacity, appreciate you.
Thank you, Your Honor. I did have an opportunity to speak to him. I read him the reports.
Who is him?
Don't interrupt.
I read him.
You just sit quietly.
Thank you.
I read him the report so that he will understand the charges against him. He didn't wish to hear anything more about his rights, and he does not wish to be represented.
Welcome to the Court of Public Opinion. I am the Recovery Addict. Do not wish to be represented. Oh man, we have some stuff to do today. A little bit of stuff. We do not have live Karen Reed trial today. The court has called it quits. No, just kidding. It's a day off. I don't know why. I think the judge had an early tea time or something. Maybe it's a pre-scheduled meet and greet with the powers that be. I have no idea. I'm purely speculating. But whatever the reason, maybe the courtroom's getting the carpets cleaned. That could be it. I think that's actually the most likely reason of all. The courtroom is getting the long overdue cleaning, and because of that, we can't watch anything. But lucky for you, and lucky for those of you who missed the beginning of the trial, I have been hard at work. I barely slept last night, putting together the best bits so far. But I'm only through most of day one. There's so many good bits, but I've cut day one down to an hour and a half. That's what I did. And I've heard a lot of things that I missed the first time around. Like I've said a lot of high praise for Mr. Brennan, and I might be taken aback. I might. I have learned this morning that Mr. Brennan does not listen to his witnesses, and that he asks terrible questions. And we're gonna relive some of that a little bit. All right. Anyway, welcome. Happy Thursday. It is Podcast Thursday. We have a podcast tonight at 8 p.m. Please join us for that. It's right here on this channel. Then tomorrow, Friday, we have court. Saturday night, live on this channel and on Valhalla Awaits will be the Lego live stream. Starts at 8 p.m., I believe, 7 or 8 p.m. It's in the evening. I'll find out for sure. So lots of stuff to do. Anyway. All right, chat is not on screen. It's not on screen because we have not yet punished Greeners, who deserves to be punished. He was first in chat. According to my record, he's first in chat. And my box is a little blurred. It's the me. Let me tell you, we turned off our power yesterday. And even this morning, after I hit the live button, I was noticing some things had not come on properly and reconnected. So you got the logo for a little while this morning while I was running around connecting cables. Turned off our power so we could pull cable. It wasn't the smartest thing. I probably should have taken a picture to show you, but my power box, if you ever take the metal cover off the breaker box where it has all the little labels and you've got all the switches in there, we took that whole metal cover off and you can just see wires. There's about 1 billion, like more cables in there than I own. About 1 billion wires in there, and 3 of them are bigger than my thumb. And with my little beep, 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 beep tester, it beeps a lot and flashes on 2 of them, and one of them doesn't beep at all.
I don't like podiums, Your Honor.
That tells me that there's power in one of those 2, probably both. Positive, negative, and then there's a neutral or something. I don't know. I didn't see it. I don't know what it is. I turned off the main breaker, chunk, like the big fat one at the bottom. Then I used my little tester again. There's still power in those 2 big beep, 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 beep things. And that's where we had to work, was around those 2 big things. So turn off the breaker did nothing but turn off the rest of the house while I could still get electrocuted. We managed to pull the cable up through there and get it coming out the box. I haven't yet connected it to the new breaker. I've realized the breaker I bought from my box does not fit. I didn't realize everyone had a different size and you had to like match the size. So I went back to the store, got a new breaker, and in the process, I turned the main breaker back on, and I turned the main breaker off, turned all the little ones off as well. Then I turned the main breaker on, and I turned each of the individual ones back on, and one of them now just flips and does nothing. It just flops. There's no spring to it. I think it's burned out, and it's a 40 amp. Hey, how's it going? I'm live. Come on in. We're going to sing birthdays in just a little bit. So we've determined that one of our outlet plugs by our previous owner had the breaker replaced by a larger and larger amp version because it kept tripping, it trips because there's a short somewhere. And so I don't know why my house is not burned down. They put a 40 amp breaker on an outlet switch, and now the 40 amp has blown. I've got cooked wires somewhere in my house. I have no idea where it goes. Zero idea what it's connected to. But I bought a new breaker. I'm going to put a 20 amp back in, and it's probably going to trip as soon as I plug it in. Or it's going to light my house on fire, one of the two. So that's exciting. So we've got a lot of things, fun things going on with the house remodel. All right, we have some birthdays coming up. Let's sing to them, and then we're going to talk a little bit about Karen Reed and some spicy bits. I've got just a couple minutes from openings. I've got a couple minutes of a few things, some cool exchanges that we might have missed the first time through. They're labeled if you're lucky. No, they're not. They're not. Do you check the copper connections? That's where I messed up over here. I haven't messed with any connections yet. Your house is a death trap. It is. 2 should have power. The third one is neutral. Where's the ground, Kevin? Shouldn't there be a ground in there somewhere? I don't think I have a ground. Maybe time to call a professional. No, as a matter of fact, it's still bare. There are wires just exposed. We've just told the kids, don't go in there or you'll die. They have these people called electricians, says Francis. Not in Eastern North Carolina, they don't. You call them and they say, if you pay us the amount you paid for your house, then we'll look at it. I just cannot afford an electrician, and plus their lead time is like we're 3 weeks out, and we'll come by and look at it to give you a bid, and the bid's going to cost you $400. But if you use our service, we'll deduct that from the cost. Like, so you get $400. You come here, you tell me it's going to cost $10,000 to pull a wire 10 feet. I don't do your service, and you just make $400 and do no work. I don't like that deal. I don't want that deal. All right, let's do the birthday stuff because it is time. We might do a house remodel stream here soon. All right, where are we at? Time for the birthdays. I'm showing that we have Linda, Sophie Nova. Which one do you want? Do you want Linda? Let's do Linda. Annalise, Pyronator, and Lynn in South Carolina all celebrating their birthday today. So we're going to sing happy birthday to them. By we, I mean all of us. That means wherever you are, stand up, take a deep breath, shoulders back, project your voice to the back of the room, blend your voice with your neighbor, warm up with me if you will. La 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 la. It was a rough start, but we got there. Happy birthday to you. Happy birthday to you. Happy birthday, dear Linda, Annalise, Pyronator, and Lynn in South Carolina. Happy birthday to you. Happy birthday, Linda, Annalise, Pyronator, and Lynn in South Carolina. Of all the special days, this is yours. I realize there are a million places you could have been. A million people you could have celebrated with, but you chose to be here with us. The privilege, the pleasure, the honor, the joy is all ours. Hopefully we can turn some of that back to you, though, and make your day a little more special. Or begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's, and Bob Evans. I had waffles myself, but it's not my birthday. Happy birthday. I hope you have absolutely the best day ever. Like an exercise beat. Can you hear it? snare is so snappy. Rosemary, you figured it out. We've got you here. Virginia Little. Wait till you hear what we've done with our plumbing. All right, the dancing continue. We're about to do the last verse. I guess not. Got 2 more verses. Why are they taking so long this time? When's the drum solo come in? Here we go. There it is. All right, everyone help me with the drum solo. If you don't have your own set of drums, just pretend you do. Here we go. Beautiful, beautiful, beautiful. Josh, did see the clips you sent this morning. I watched one of them for about 40 minutes, realized I was watching the wrong one at the wrong timestamp. And I'm like, I don't know what he sees in this. But you did send some other ones. We might get to them. But I do want to do a little recap because that's what we called the live stream here. RA is off today, but we're here for you. There you go. Thank you. Happy birthday to everyone who's celebrating. 80s, as always. Perfect. Let's see. Day one in this trial was amazing. And I grabbed just the best bits for you. If you missed the beginning of this trial, if you thought for some reason, I just can't get into the Karen Reed trial one more time. I sat through it the first time and it was just too much for me. And now it's sort of grown on me. You've sort of weaseled your way in and like, well, I think I could listen one more time. But you missed that first day. This is for you. And I've got it all on the replay slow-mo machine so we can take a gander and listen. And it goes so fast. All right. Here we go. Are you guys ready? Buckle up. Court's about to be called into session. Here we go. Oh, it helps if I both show you. I've learned some things about YouTube over the years. It helps if I both show you the video and play it for you so you can hear. So this time I will do that. There we go.
So good morning. I see all counsel are present. I see all counsel are present. Nobody said anything to Mr. Clerk about needing to see me, but I received 4 motions over this weekend that I assume we need to at least talk about briefly. Commonwealth's motion regarding defense opening statement. I think the first 2 motions we can do quickly. I'm not issuing an order. Mr. Brennan, the defense knows third-party culprit will not be in the opening. If you think that their opening goes beyond it, you can object. Defendant's opposition to the Commonwealth's request for use of independent readers, because there's an objection, the defendant's motion's allowed. So you will not have an independent reader.
So fire your
reader. Is it fair to say that the 3rd and 4th motions, Commonwealth motion to enforce compliance with court's April 16th ACCA discovery order and the Commonwealth's motion to preclude new expert testimony or alternatively to continue the trial date, that those motions will take a little bit of time, Mr. Brennan?
Yeah.
I don't think I'll be long in my argument.
I think that I need more information on one of them. And I think we'll do that at the end of the trial. At the end of today, we'll hear both these motions. Mr. Jackson, I did see that a list of text messages, 100 or so, is in your response to my order on Friday. Did you provide the text messages themselves?
No, Your
Honor. All right. In light of that and the fact that we don't have time, the juror's been waiting for some as many as 3 weeks now, I'm going to prohibit you from mentioning ACCA in your opening statement. And then we'll deal with this later today. I ordered those text messages and they weren't delivered. So we're going to be bringing the jury in. I'll be in recess for 5 minutes.
On that, I think the court respectfully may be factually incorrect on a key assumption of what Your Honor is ruling.
5 minutes, Mr. Alessi.
Mr. Jackson's going to give you the facts. I would like to hear the law.
That's more than 5 minutes. I'll see you at sidebar. Come up here.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannoni, the Justice of the Superior Court, now holding in Dedham, within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
I expect him to say God save the Queen. as well.
2282CR117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
Morning, Your Honor. Adam Lally for the Commonwealth.
Morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Morning, Mr. Brennan.
Morning, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. Good morning, jurors. So I have 3 questions I have to ask you because I haven't seen many of you for a long time, and we do appreciate that you're all
She stands
here,
up because she
ready,
can't see all the
willing, and
jurors
able
when
to
she's
get
seated.
started early. We sometimes have to
Her desk's
deal
too
with
big.
a few things before bringing you in, but we do appreciate your patience. So
Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022, at Canton in the County of Norfolk, did assault and beat John O'Keefe with intent to murder such person, and by such assault and battery did kill and murder the said John O'Keefe, and is guilty of murder in the 2nd degree and not in the 1st degree in violation of Massachusetts General Law, Chapter 265, Section 1. 002, Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022, at Canton in the County of Norfolk, did operate a motor vehicle upon a way as defined in General Law, Chapter 90, Section 1, or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, with a percentage by weight of alcohol in her blood of 8/100ths or greater, or while under the influence of intoxicating liquor, and did so operate said motor vehicle so that the lives and safety of the public might be endangered, and by such wanton and reckless conduct so described to cause the death of another person, to wit, John O'Keefe, in violation of General Law, Chapter 265, Section 13 and a half. 003, Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022, at Canton in the County of Norfolk, did operate a motor vehicle upon a way or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, and without stopping and making known her name, residence, and registration number of her motor vehicle, to go away to avoid prosecution or evade apprehension after knowingly colliding with or otherwise causing injury to John O'Keefe, such injuries having resulted in the death of said person in violation of General Law, Chapter 90, Section 24, Subsection 2, Subsection A and a half, Subsection 2. To these indictments, the defendant has pled that she is not guilty and for trial has put herself upon the country which country you are, and you are sworn to try the issue. If she is guilty, you are to say so. If she is not guilty, you say so and no more. Jurors hearken the evidence.
So much formality there.
thank you. So it's now time for the opening statements. Mr. Brennan.
Thank you, Your Honor. We are here today because
Why does
by the actions and conduct of that defendant, Karen Reed.
I don't know why the audio.
You will learn through this case, through facts, science, and data, you will learn that on January 29, 2022, when the defendant and Mr. O'Keefe were in front of 34 Fairview Road, all the way to the left side in that dark corner near a flagpole, you will learn that Mr. O'Keefe got out of the car. He got out, and as he stood by the side of the road, after an argument with the defendant, that argument, that anger fueled by heavy intoxication, you will learn from the science and data as he stood by the side of the road, the defendant in her SUV drove away. She drove at least 35 feet away. The argument was over. It had ended. But then she stopped. She stopped. She put the Lexus into neutral, and she waited 2 minutes. And the facts and the science and data will tell you that despite the fact the argument was over, she then put the Lexus into reverse, put her foot on the gas pedal, and began to press, not 25%, not 50%, up to 75% acceleration. There was a light dusting of snow. The Lexus tire spun backwards. She went backwards at least 70 feet. She clipped John O'Keefe, who fell backwards, hit his head, broke his skull. And there he lay at the corner of Fairview Road. on the ground, lying on top of his cell phone, alone. And then the defendant will later tell that when she left, he didn't look mortally wounded. Yet he was. And she simply drove away. Ladies and gentlemen, I simply ask you to follow the evidence, follow the science, follow the data. Ignore speculation, surmise, conjecture. Stay true to the evidence. It will lead you to the truth. That on January 29, 2022, a very intoxicated defendant was angry and arguing about the relationship with John O'Keefe. And after the fight was over, she left, but she brought the fight back to him in the form of her SUV. She clipped him, he fell backwards, he broke his head, and then this man who helped, a lifetime of help, was left at the corner of that yard, left to die with no help.
Listen carefully here.
The facts, the data, and the evidence will bring you the truth, and the defendant's own words will confirm everything you've already concluded.
The defendant's own words will confirm everything you've already concluded. Everything you've already concluded. What? Opening statements are not evidence, and he's telling the jury they already know what happened, and they're done. We're just gonna rehash that for you in the trial. I didn't catch that the first time. Everything you've already concluded. And now, defense.
The evidence in this case will establish above everything else 3 points. There was no collision with John O'Keefe. There was no collision. There was no collision. John O'Keefe did not die from being hit by a vehicle. Period. The facts will show that. The evidence will show that. The data will show that. The science will show that. And the experts will tell you that. You'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, there was no collision with John O'Keefe. So how did we end up here? How does Karen Reed end up sitting in that chair on trial for an event that literally never happened? Well, the evidence is going to explain it. And it can be summed up in the following text message at the very beginning of this investigation. A text message of a now fired Massachusetts State Police officer named Michael Proctor.
Welcome,
Who's the lead investigator on this case. And he was talking about a fellow officer, a fellow cop, who owned the property where John O'Keefe's body was found. Text message with a buddy. Question, is the homeowner going to catch any shit? Answer, nope. He's a Boston cop too. That quote defines the lack of integrity of the Commonwealth's entire case, its entire investigation, and this prosecution. During the course of this trial, you'll learn much more about Mr. Proctor, why he said that, and what it really means. What you'll see and hear in this courtroom in the coming weeks is not just a story of a tragic loss. And make no mistake, John O'Keefe's death is and was a tragic and tragic loss. But the story you'll hear is about an investigation that was riddled with errors from the beginning, a rush to judgment, conflicted, and corrupted from the start. Corrupted by bias, corrupted by incompetence, and corrupted by deceit. Finally, it was corrupted by a deliberate effort to avoid and to cover up the very truth that you are seeking. By the end of this trial, you'll conclude that Karen Reed is not guilty of hitting John O'Keefe with her SUV. There was no collision. She's the victim of a botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty. You'll find that this case is the very definition of reasonable doubt. And at the end of this trial, we'll ask you to return the only verdicts, all three of them, that are consistent with the evidence, the science, the truth, and justice. Not guilty, not guilty, not guilty.
The 3 times they're repeating.
Thank you.
These are things I pick up when the
Mr.
rewatch.
Jackson. Folks, why don't we take our morning recess?
Okay. Quick break, and we're back. There's our only fan. You're unmuted.
All right, Mr. Brennan, your first witness, please.
Thank you, Your Honor. The Commonwealth calls Timothy Nuttall. Good morning.
Good morning, sir.
Could you please introduce yourself to the jury?
So my name is Timothy Nuttall. I'm 28 years old. I've been a firefighter paramedic ever since I graduated high school. I graduated in 2015. I took my EMT class and got my certification while I was actually still in high school.
What happens next?
So I got in the back of the truck. I was actually still in civilian clothing at the time because I had just walked in the door. So I got in the back of ambulance one in the patient compartment. The other 2 gentlemen were up front driving to the scene. I actually had to don my turnout gear because, again, I was in civilian clothing. I wasn't quite ready to go. So I had to put all my structural turnout gear on and then my Canton Fire jacket. Once I was sufficiently dressed for the call, I started prepping all the gear that we might need for a call such as that, for an unresponsive male in the snow. In this case, it was our first in bag, our airway bag, and our cardiac monitor. Everything was all together. They were all in 3 separate bags. But on the way there, I just got in. I didn't know how their night had gone, so I just took a real quick look at everything just to make sure everything was there and everything was exactly how it needed to be. So I was able to just grab all 3 bags, put them on my person, and get ready to, so as soon as the ambulance was on scene, just step off and go to work. And once I was able to get around the side of the truck, that's when I was able to see a group of 3 individuals with Canton Police, and I started making my way over to them to see where the patient might be located and what was going on.
As you get closer, tell us what you see.
So as we approached the scene, as I said, there were 3 individuals, and Canton Police were on scene as well. And then there was what appeared to be a human figure laying supine in the snow. I'd say about 6 to 8 feet, kind of where the sidewalk met the front lawn of a residence.
What does supine mean?
So that he was laying on his back. Okay. From there, I made my way directly over to that individual and started checking for signs of life. I saw a middle-aged middle-aged female with blood on her face, and real quick, as I was in the process of providing ventilations, I said, "Do you know this person?"
The person that you looked up and saw that was standing over you with blood on her face, do you recognize that person in this courtroom?
Yes, sir.
With the court's permission, sir, could you point out that person that you looked up and saw?
In between Mr. Jackson or next to Mr. Jackson. He doesn't know the other one.
And when you looked up and saw
he nods
that
to
person
him. Hey, you.
And asked about any background, what did she say to you?
I hit him.
How clearly do you remember her words saying to you, I hit him, I hit him, I hit him?
I remember it very distinctly.
Sir, do you recognize what's in that photograph?
Yes, sir. Those are the scratches on Mr. O'Keefe's arm.
Does that appear the same as when you saw his arm that morning, or is there any differences? And if there's any differences, can you share them with us?
That appears how they were to me at the time of the incident.
Okay.
Good morning, good afternoon, Firefighter Nuttall.
Good afternoon, sir.
Nice to see you again.
You as well.
Before your testimony this morning, how many conversations had you had with any member of the prosecution team in anticipation of your testimony today?
I believe it was 3, sir.
When were those?
I could not give you dates off the top of my head.
Give me a time frame. Within the last 3 weeks, within the last 3 months, last 3 days?
Within the last 3 weeks, I believe one the week after that, and then one last night.
One?
Last night.
Last night.
All very recent.
Were there any issues that Mr. Brennan or anybody else in that meeting brought up concerning any of your testimony?
There was just a question of how many times the I hit him came up. It was 3 times.
And were you advised that that's not what you said at your testimony last year?
No, sir.
2 times?
What was that?
You said it was 2 times last year?
I honestly can't recall, sir.
Okay, but you just saw that, or you just read that and went over that 3 weeks ago.
I believe so, sir, yeah.
But you can't remember, as you sit here today, just 3 weeks ago, what y'all discussed in terms of how many times you previously testified that you heard the phrase, I hit him.
So previously testified possibly to 2, but it was 3.
Okay, your memory is clearer now than it was, for instance, a year ago when you testified.
Repeat that?
Sure. Your memory is clearer now, as you sit here, that it was 3 times you heard that, than it was a year ago when you testified that it was 2 times.
Yes, sir.
Okay. Does your memory get better with time generally? Your memory. I'm not talking about the royal you. I'm talking about you.
In certain settings, I mean, there are certain things about different aspects that I recall better than others.
Okay, and does your memory tend to get better, or does it fade over time? That's my question.
It can fade over time, but it depends on the context.
But in this case, you're telling this jury that your memory is better now than it was a year ago when you testified about the exact same circumstance, correct?
Yes, sir.
Okay.
Okay. Look at the faces.
If y'all had met 3 weeks ago and you indicated to Mr. Brennan that it was actually 3 times, not 2 times that you heard the I hit him, why did you need to discuss it again a week later to verify the 3 times versus 2 times?
I'm not sure, sir. That was just the way that the conversation went. And I just, again, repeated what I said and what I remember from that morning.
Well, tell me about that conversation. Did Mr. Brennan say anything like, well, are you really sure that she said it 3 times?
It was that morning what was said to you. And I said, I hit him. That was how it went that morning, and that was how I remember it.
Okay. And did Mr. Brennan say, well, that's not consistent with how you've testified previously concerning the number of times you heard the I hit him phrase?
Yes, sir.
He did say that.
He wanted to, he acknowledged that I had said it twice. However, again, as I mentioned, it was said 3 times to me.
So now you do remember last year that you only said it, you only said that it was repeated twice.
One more time, sir.
So now you do recall that last year when you testified, it was inconsistent with how you're testifying today. Let me put it that way. Correct?
I believe I said I hit him twice on the stand last year.
Right. And if you're saying I hit him 3 times instead of twice, that, Firefighter Nuttall, is inconsistent with your testimony today, correct? You
yes,
agree
sir,
with that?
But that is how it went that morning, though, sir.
Okay, that's not my question. Let me see if I can do it again. So I'm asking you, if you testified last year,
yes, sir,
that you heard the phrase twice,
mm-hmm.
and now a year goes by, and you're testifying in front of this jury this year that you heard it 3 times, those 2 statements are inconsistent with one another, correct?
Yes, sir.
Okay. Did you talk at the meeting 2 weeks ago about any other inconsistencies with your testimony?
Not to my knowledge, sir.
Well, you were there. You
No.
say not to my knowledge, meaning?
No, sir, we did not.
Okay. So it was just about the number of times that you heard the phrase, I hit him, correct?
Yes, sir.
All right. You cleared that up in the 2 meetings, 3 weeks ago and 2 weeks ago. What did you talk about last night?
Mostly just making sure that everything was as it had been. I mean, and by that, I mean, it was 3 times, and that we were continuously making sure that everything was the way that it it had happened that morning.
Everything was the way that Mr. Brennan wanted it to be.
No, sir. The way that it was in, I remember it, and I recall it happening.
Okay, so he asked you 3 weeks ago about how many times you heard that phrase.
Yes, sir.
You changed your testimony at that time and said it was 3 times instead of 2 times. We agree on that, correct?
Yes, sir.
Then he called you a week later, or met with you a week later, and again reiterated, making sure
This is so funny.
you stick with that testimony that it's 3 times, not 2 times, correct?
Yes, sir.
And then last night he called you just to make sure one more time you're going to stick with that testimony that it was 3 times, not 2 times, correct?
Yes, sir.
Hold on just a second. May I have just a moment, Your Honor?
Yes.
All right, now that we got that squared up, look at the faces.
Okay. And when you talked last night, did you assure Mr. Brennan, nope, when we come in tomorrow, I'm certainly going to say it was 3 times, not 2 times?
No, sir. I told him I would tell my recollection of that morning.
Okay. And did you tell him that what my recollection is, I'm going to tell the jurors it was 3 times that I heard it?
That was what I heard.
Okay. Did you tell him that's what you were going to say today?
No, sir.
You didn't?
I told him I was going to tell him what I remembered from that morning.
Which was what?
I hit him, I hit him, I hit him.
Which is how many times?
3 times, sir.
And that's inconsistent with what?
I believe a year ago.
Okay. Now, you also talked about, I want to get back to the other thing that you talked about. You said that at some point, either in the meeting 3 weeks ago, the meeting 2 weeks ago, or the meeting last, you testified.
Sorry, I cut that off.
Previously at the grand jury in April of 2022, correct?
Yes, sir. I believe so, sir.
Okay. So this happened in January of 2022, that same year in the springtime. You testified at the grand jury, April 20th, I think it was.
Yes, sir.
Does that sound right?
Yes.
Okay, I want to take you back to that testimony for a second. You testified at that hearing that Mr. O'Keefe was, quote, dressed appropriately for the weather. You remember that?
Yes, sir.
All right. It was obviously well below freezing at that time.
Yes.
That night that you responded?
It was.
We've just seen the video. It looks cold as hell, right?
It was chilly.
All right. The wind was howling.
Yep.
It was snowing. Is that right?
Yes, sir.
And you testified that John O'Keefe, quote, had a heavy coat on and possibly 2 other layers of clothing.
Yes, sir.
In April 2024, you reiterated your very specific memory of and you even called it a puffy heavy coat that he was wearing, which was then removed so that you could assess his injuries, correct?
Yes, sir.
All right. Not to get too colloquial, but a puffy coat is like, it's got down and stuff in it, right?
Correct.
Looks kind of like Stay Puft Marshmallow Man, right?
Yes, sir.
Okay. Pretty distinctive article of clothing.
Yep.
And you testified last year that Mr. O'Keefe was wearing that clothing, which you had to remove, or somebody had to remove, in order for him to be properly assessed.
I did testify that way, yes, sir.
Okay. And you mentioned that your memory of that big, heavy winter coat was as clear as your memory of other specifics in this case, correct?
Yes, sir.
I asked you that exact question, didn't I?
You did.
And I said, your memory of him having that big, puffy coat on, which stood out in your mind, was just as clear as the other specifics that you've testified to about the case.
Yes, sir.
About that night. And turns out you were completely wrong about his clothing, correct?
Correct.
Matter of fact, he wasn't wearing a coat at all.
No, sir.
He wasn't wearing a winter coat, correct?
Nope.
He wasn't wearing a heavy winter coat, correct?
Correct.
And he wasn't wearing a puffy, heavy winter coat.
He was not.
Yet you testified that he was wearing all of that, and that was clear in your mind at the time.
Yes, sir.
Oops.
Did Mr. Brennan bring that up during the meeting 3 weeks ago?
He asked about what I had meant when I said appropriately dressed.
So you did talk about something other than just the I hit him, correct?
Yes, sir.
When I asked what y'all talked about, why didn't you tell us that?
To be perfectly honest, sir, I did not remember until right now.
That's a terrible answer, too.
So your memory is fading even after 3 weeks.
Yes, sir.
Got it. I'm asking about a general debrief with the fellow firefighters, male and female, that you were with at that scene. You're telling me that you don't remember debriefing and discussing the incident and your observations at the incident following that incident.
No, sir.
Okay. But your memory, you indicated earlier, gets better with time, right?
Yes, sir.
You don't remember it as you sit here today?
Ask the question again?
Sure. Do you remember discussing with firefighter Flamati, firefighter Walsh, firefighter Kelly, or firefighter McLaughlin, any of them, your observations and what happened while at the scene after you cleared the hospital and got back to the station?
No, sir.
Have no memory of that whatsoever?
No, sir.
Did you tell Trooper Proctor on February 8th that what you heard was Karen Reed speaking to a female, not answering a question that you posed?
Again, I don't recall that specific question.
Did you tell Trooper Proctor on February 8th while you were rendering aid, and at the time you heard the statement, Miss Reed was actually praying over John? Your words, praying over John.
I don't recall ever saying that.
He mouths, I don't recall ever saying that, ever.
Yes.
Does a couple more faces.
May I approach, Your Honor?
Yes.
Sir, did you have an opportunity to glance at the report that you were just shown?
Yes, sir.
Does that refresh your recollection about your conversation with Trooper Proctor that he put in a report?
It does not, sir.
So as you sit here, you have no memory of what you just read in this report from Trooper Proctor, the lead investigator on the case?
I have no recollection of ever saying that anybody prayed over anybody ever in this case.
You did see it in his report, though.
Right.
Sustained.
You've admitted under oath that your memory of the events at that time, from that time frame, January, February 2022, is faulty, correct?
No, sir.
In your April 2024, it's April 30th, 2024 testimony from last year, you were asked whether or not your memory was a little faulty, and your answer was absolutely, correct?
Could I have a page and number,
Where is
please?
that, Mr. Jackson?
Volume 8, page 151, lines 14 through 16.
It's got the receipt right there.
In answer to the question, quote, so it's fair to say your memory is a little bit faulty as it pertains to that time frame, your answer was absolutely, correct?
From last year?
What you testified to last year about conversations that you had with Trooper Proctor around February 8th of 2022.
Yes, sir.
And you would agree, as you sit here, that your memory is still faulty about your conversation with him, correct?
With Trooper Proctor? Yes,
Yeah.
sir.
So you're not saying you didn't say that the statement was made to a woman, correct?
Objection.
Are you saying that?
No, ma'am.
Okay, next question.
Thank you. And you're also not saying that you didn't say to Trooper Proctor that you saw Karen Reed praying over John O'Keefe.
Objection.
So I'd like you to ask that differently. Did you say that?
I have no recollection of saying that ever.
Okay. Next question.
My point is, if you have no recollection of it, you're not denying saying it.
Objection.
Are you denying saying it?
Yes.
Okay.
So you do have a recollection that you never said it. Do you understand the difference?
Oh, sir, I don't believe I've ever said praying. That's really not something that I would have said. I didn't see it that day. It didn't happen. I don't remember ever saying prayed.
You didn't
in regards
see it
to this case ever.
You didn't see it that day, and it never happened. That was your words just now, correct?
Break that down for me.
You didn't see it that day, and it never happened. That's what you're saying about the praying statement, correct?
Yes, sir.
And in that same exact statement, you also included the phrase, I hit him, correct?
No, sir.
In the statement that you made to Trooper Proctor?
The report that Trooper Proctor wrote?
Correct.
Again, I don't remember ever saying the words praying over him. I do distinctly remember I hit him, I hit him, I hit him.
Which doesn't appear in that report, does it?
Objection.
I'm going to sustain that, Mr. Jackson. You directed him only to page 2.
Understood, Your Honor. You met with me 3 times?
Yes, sir.
I had not met you before any of your prior testimonies, had I?
No, sir.
Do you remember meeting with me and discussing this case with me?
I do.
Do you remember me asking you to tell me what you remember?
I do.
Do you remember what I told you about testimony when you come into court?
Back on direct.
Yes, sir.
What would I tell you?
I remember we discussed that just tell the truth.
Did I tell you that it doesn't matter, there is no side, doesn't matter if it helps or hurts, that you just tell the truth?
Sustained.
Did I ever suggest to you that you should stick to a story?
No, sir.
Did I ever suggest to you you should offer your testimony in any certain way?
No, sir.
When I talked to you, did I ever ask you to say anything about your testimony to this jury?
No, sir.
Other than what?
Speak to the jury.
Did I need to tell you to tell the truth?
No, sir.
Speak to the jury.
And in telling the truth, did the defendant say to you, I hit him, I hit him?
Objection. I'll allow it.
Yes, sir. 3 times.
And in fact, do you remember, in addition to her saying, I hit him, I hit him, I hit him, when you asked her the question, kneeling down over John O'Keefe's body, do you remember if you ever talked about other times that she said it, not to you?
Did you ever?
I do not.
Okay.
Objection.
The answer is I
do not.
Next question.
Okay.
Okay, he says Brennan.
Do you remember testifying previously in this case?
Yes, sir.
No, he has to impeach his own witness because he answered wrong.
Do you remember at all discussing whether or not, after she left you, whether or not the defendant was still talking and speaking?
I'm sorry, sir. Repeat the question.
Do you remember, after the defendant left you and made that statement to you, do you remember talking, did you hear her speak to other people after you?
I heard her having conversations in the background, but that was not my focus at that time.
Okay. And during those conversations in the background, did you hear her talk about that same issue again?
I believe she said it several times, but the 3 times she said it to me were what stuck out to me.
Okay. And when she said it to other people, it wasn't directly to you?
No, sir.
So watch the form of the question, Mr. Brennan.
And when she said it
to the objection.
When she said it to other people, do you know who she said it to?
I do not.
That was the same question.
I'll allow it. So the answer is I do not.
I'm sorry.
I do not.
Do you remember when
Hang
she
on.
said it other...
Stop. Rewind. Okay, listen to this again.
No, sir.
So watch the form of the question.
Here's the question.
And when she said it
Sustaining the objection.
When she said it to other people, do you know who she said it to?
I do not.
I'll allow it. So the answer is I do not.
I'm sorry.
Do you remember when she said it other times who she said it to?
I'm going to see counsel at sidebar for this.
Fun little sidebar. Kept getting the answers wrong. And he's looking over at the jury. He's like, I'm doing pretty good.
Sir, after the defendant came over to you and spoke and then left, do you remember hearing her make further statements?
Yes, sir.
And do you remember her making further statements similar
I do.
to the statement to you?
Yes, sir.
Could you share with the jury what you remember her saying, not to you, but after she left you?
I remember hearing I hit him several other times. Again, not directed to me, just kind of off in the background. I'd like to reiterate, we were really focused on the patient at that point. We were trying to provide care.
Thank you, sir.
Recross.
So now, after Mr. Brennan asks you a few questions, now you remember her saying, I hit him a bunch more times. Correct?
I remember hearing it in the background several other times.
Really?
Yes, sir.
Never mentioned that on direct examination, did you?
I don't remember being asked about it, sir. I remember saying what was asked to me.
You were asked, did you ever hear the defendant, Ms. Reed, say anything about I hit him? And your answer was, she said to me, in answer to my question, I hit him, I hit him, I hit him 3 times, and that's it.
To me.
You didn't clarify that, oh my gosh, she's running around like a chicken with her head cut off, screaming I hit him to everybody else under the sun.
It was, again, It was behind me in the background
Right.
as I was providing patient care. Again, that was not my focus.
Okay, so you didn't really hear her say anything in the background because you weren't focused on that, right?
I remember hearing a generalized commotion in the background, but again, that was not our focus.
So generalized commotion is very different than hearing her say, "I hit him," to other people. Correct? You'd agree with that?
Yes, sir.
So what you actually heard was the chaos and the commotion of a chaotic scene, correct? In the background.
In the background.
As you focused on your patient care, correct?
Yes, sir.
Okay, not specific words coming out of my client's mouth, correct?
To the question that I posed, do you know him?
You're right. We're off that question.
Okay.
That question, I got it.
Yes, sir.
Triple I hitters.
Correct.
But with regard to what Mr. Brennan just asked you, the generalized commotion, to use your phrase, in the background, you didn't hear any specific words coming out of my client's mouth, did you?
I heard I hit him. But again, it was in the background and it was not my focus.
Thank you. I now call Carrie Roberts.
There you go. That was first witness. Witness number 2,
All right,
Carrie
Mr.
Roberts.
Brennan, whenever you're ready.
Thank you, Your
afternoon,
Honor.
Ms. Roberts.
Good afternoon, ma'am.
Good afternoon.
She didn't have any mic drop moments.
Introduce yourself to this jury.
Hi, my name is Carrie Roberts.
Listen to Brennan's
Roberts,
questions
where do you
here.
live?
I live in Canton, Massachusetts.
How long have you lived in the area for?
Dangling
I was
participle.
raised in the Boston area, North Shore, South Shore. I went to high school in Braintree, and I moved to Canton about 12 years ago.
Do you live alone?
No, I live with my husband and 2 children.
Are you single? What was
You
that
have 2
question?
children? You're
Yes.
married?
Yes,
And you live in the area?
yes.
I want you to tell us whether you know a person by the name of John O'Keefe.
Yes, I do.
Were you close friends before he took over the care of the children?
No, I wasn't very close friends with him then.
Were you close with his family before he took over care of the children?
No.
Did your friendship with him develop after he took care of the children?
Yes.
Could you tell us a little bit about your relationship with John?
John and I were very close. We spoke on the phone and hung out. He became very close with my husband as well because he was right down the street. But we just had a friendship, a very close friendship.
As you grew closer to John and helped with the children, did you become closer with his family?
Yes.
And who specifically did you become closer with?
Mrs. O'Keefe and Mr. O'Keefe, his parents, and Paul I would see from time to time, but not a lot. He doesn't live in Canton. But Mr. and Mrs. O'Keefe would be there all the time to help as well. And Mr. O'Keefe would take my son and Patrick, the nephew, out to Dunkin' Donuts all the time.
Did you know Jen McCabe?
I had met her once, but other than that, I never talked to her on the phone. I never saw her out. Her children are older than mine, so we never really crossed paths.
And from that time you met Jen McCabe in the years past, did you ever spend time with her again before January 29th, 2022?
No, I did not. I didn't know her.
Were you friends with her?
I was not.
Did you speak on the phone with her?
No, I did not.
So other than that one meeting, you were strangers?
Yep, that was the only time. I knew her. I knew of her. She has 4 girls, but I didn't know her.
At some point, as you were part of John's life, did you learn that he was dating a person by the name of Karen Reed?
Yes, I did.
And do you see that person here in the courtroom today?
Yes, I do.
Could you point her out and describe an article of clothing that she's wearing?
She has a black suit jacket seated at the front table.
I think it's the
Briefly, just tell us a little bit about where and the circumstances of meeting John and Karen for the first time.
They came over to my house and we hung out on the back porch, had some drinks. There was music. Kids were around. Just a nice, normal summer night. We had other people over as well.
Over the next coming months, did you become more familiar with the defendant?
Yes.
Did you see her more often?
Yes.
How many times had you been to John's home, would you say, over the past couple of years before this night?
Oh, many.
Many times?
Many times.
Were you familiar with the house and the driveway?
Yes.
May I approach you, Honor?
Yes.
Should I return to the podium and ask the questions?
You
now?
can ask them from there.
Thank you. Ma'am, I'd ask you to take a look at that photo in front of you. Do you recognize what is in that photo?
That is John's house.
Is that a fair and accurate depiction of how his house looks?
Yes, it is.
You can take it down. I've shown you a second photo. Do you recognize what's in that photo?
Yes, that's John's driveway.
Is that a fair and accurate depiction of how
We don't get to
John's
see that one.
driveway appears?
Yes, it is.
I'd move that into evidence. No objection.
Okay.
I'm showing you a third photo. Do you recognize what's in that photo?
Yes.
And could you share with the jury what's in that photo?
It's the side of John's house looking up from the driveway.
Is there anything you notice on the side of the house?
The lights or the Ring camera.
Are you guessing, or do you know that's a ring
No,
camera?
I know there's one there
And how do you know that?
because I got a Ring camera and I could look and see who was at my door. And then he said, "Why didn't you tell me about these things?" So he bought one.
Ms. Roberts, with the laser pointer, could you just point at the picture and show where the Ring camera is?
On this screen?
Yes, please.
Whichever one you can do.
Okay. Why isn't it working?
Because it's a bright picture.
It's on.
Okay, well, you know what? Rather than use the pointer, why don't we describe? Can you describe where you see the Ring camera on that picture?
It's in where the two lights are under the top window.
Okay, thank you. How many times would you guess you had been over to his house?
Second time you asked that.
I don't know. More than 50,000. I don't even know. A lot. It was
50,000.
weekly.
What was the forecast for that night and the next morning?
There was a blizzard coming.
Did you look outside? Do you have any memory of what the weather looked like around 10:30?
What's the weather like?
I remember the snow started to fall somewhere around 12 because I remember looking out the window and I could see it starting.
What was the weather out that night?
The weather that night, I think, was fine. It was cold, but it wasn't snowing yet.
I see. I want to move forward ahead. At some point that night, did you go to sleep?
Yes, I did.
Did you sleep through the night, Ms. Roberts?
Yes, I did.
At some point, did you wake up?
Yes, I did.
I want you to tell us what was the reason that you woke up.
I got a phone call at 5 o'clock in the morning from Karen Reed.
Were you expecting a call?
No, I was not.
Had you ever received a call at 5 in the morning from Miss Reed before?
No.
Share with us what happened that morning. What did you hear?
Karen called and the first thing she said was, Carrie, John's dead. And then she hung up.
3 times.
When she said that, did you have a chance to have a conversation with her?
No, I did not.
Describe her demeanor when she said that.
She was yelling loud enough, my name, I think it was 3 times, it might have been 2. She was yelling loud enough that she woke my husband.
Might have been 2.
Your husband was sleeping next to you?
Yes, he was.
Was she loud, yelling, screaming?
Yes, she was very loud. She was screaming.
After she said, Carrie, John's dead, did you know what she meant?
No.
And did you say this was around 5:15?
This was at 5. She called me at 5 on the dot.
Did you have another discussion, or did you hear her say something else the second time you spoke to her?
Yes, the second time she said, I think something happened to John. I think he got hit by a plow. He didn't come home last night. Kaylee was home. He would never leave her by herself, and I was not supposed to stay at the house last night. So I think something happened to him.
Did she say anything about drinking?
Yes, she said, we drank so much, I don't remember anything from last night. And I said, okay, where are you now? She said, I'm driving. And I said, you need to go home. Where's Kaylee? And she said, at home. I said, you need to go home and be with Kaylee. She cannot handle this, thinking, her uncle's missing. I said, you're going to get a DUI. You need to go home.
Kathy, welcome
Was
to the
there
jury.
anything else in the conversation that she said to you at that time?
She said, I'm going to drive to your house. Would you drive my car? And I said, yes.
As you were waiting for the defendant, did you make any other phone calls?
I did. When I was in the car, I thought to myself, well, she thinks he got hit by a plow. I'm going to call the police and see if there was any accidents or maybe something happened. They brought him in. And I spoke to the officer who said, no, nothing of that sort. I've been here all night. And then I called the Good Samaritan Hospital and Milton Hospital to see if they had anybody that was taken in an accident.
You said that night when you went to bed, the snow just started. Had snow accumulated at that point?
No, I don't think so. It was just starting to stick.
I'm sorry, that was the night before, but at this point when you were in the driveway, had the snow accumulated?
Oh, yes.
Do you know how many inches it was?
Subtle
No,
correction.
I don't.
Okay.
Enough that the plows are out.
As you were waiting for the defendant, did she arrive at your house?
She did not.
What happened?
Again, I don't know if I called her or she called me, but eventually we connected on the phone and she said, I said, where are you? I'm waiting. And she said, I'm at Jen's house. And I said, Jen who? And she said, McCabe, she's going to drive my car. And I said, okay, well, listen, they don't want cars on the road because it's so bad. I'm already in my car. I'll come there to Jen's house, stay there, and we'll follow each other and we'll go back and drop your car off. Did you look in the house for John? Could he just be in the house, passed out somewhere? And she said, no, she hadn't looked in the house. So I said, okay, now I'm going to come to Jen's. We're going to take the car home, drop it off. We'll check around the house. And then I don't know what the next step at this point was. I just wanted to check the house.
As you drove over to Jen McCabe's home and you had some guidance finding it, did you hear any conversations in that open line with, or even any statements by the defendant?
I remember when I pulled in behind her car in Jen's driveway, and at some point Karen said, my taillight, and I looked, and Jen she must have had the brake done because you could see that there was missing taillight.
When you say missing taillight, was it merely cracked?
No, there was a piece missing.
Could you see that as you were parked right behind the defendant's SUV or Lexus?
She must have been applying the brakes because you could see it, but there was a lot of snow.
When you saw that the taillight had a missing piece, did you say anything?
No.
Did you think anything of it?
No.
How long were you parked behind the defendant's Lexus while it was parked in Ms. McCabe's driveway?
Not long. We were just, I pulled in and then we stopped, and then the next plan, at some point in that conversation as well, or maybe on the ride, because now we're heading to John's house to drop a car off. I pulled out of the driveway, Jen pulled out, and I followed behind all the way to John's house. And at some point, Karen said, I left him at Waterfall. And I heard Jen say, no, I saw you pull up in front of my sister's.
You followed Ms. McCabe?
Yes.
Where did you go?
To John's house.
Did you arrive?
Yes.
When you arrived at Mr. O'Keefe's home, you were in two separate cars. Who pulled into Mr. O'Keefe's driveway first?
Jen pulled Karen's car in first.
So Ms. McCabe was driving the Lexus?
Correct.
And the defendant was in the passenger seat?
Yes.
Okay, we're going to pause for just a minute. She goes on. She describes the search for. Well, she describes looking at the tail light in the driveway. She also describes searching the house for John, and then driving and going in the car, and Karen talking in the car, saying something's wrong, and constantly talking, and she's telling her to shut up, and there's probably not, you're not making sense, everything else. Continues all the way to the end of the day, where the judge cuts them off a little bit. Gets cut off because they have something else to discuss at the end of the day. And it has to do with, if we can get there. Here we go. Has to do with those motions that were filed over the weekend. And so we're going to watch all that argument. And it starts with Mr. Brennan really laying down the case for what he hopes to be a big win in shutting down the defense use of ARCA.
Please be seated, court is in session.
Big sigh.
All right, so we'll have a quick hearing on paper now 682 and 680. First, Commonwealth's motion to enforce compliance with the court's April 16th, 2025 ARCA discovery order. Mr. Brennan, you said you could be brief on both of these, so I'll hear you.
So be brief.
Your Honor, I'll get right to the point. On the motion for compliance, our position is that the defense did not comply with your order. This has been an ongoing issue which relates directly to the credibility of potential ARCA witnesses. This is information based on the history and representations made in this case that we're entitled to. I did note before these were produced that we have watched video footage from unaired video from the documentary. We clearly knew that there were text messages and correspondence beyond what was represented to the court. It is not a surprise that I did receive these lists of text messages and calls after I made those comments. However, there is no text message content. There is 99 texts to Mr. Wolf, 6 texts to Mr. Rentschler. That does not reconcile with the past positions and representations of the defense to this court and to the Commonwealth. In addition, there are a number of phone calls. And those phone calls, again, I would suggest do not reconcile with the past representations. We have 52 minutes of phone calls on 5 calls with the ARCA mainline, 133 minutes, 20 calls with Dr. Wolf, 57 minutes, 23 calls with Dr. Rentschler. I find it difficult to accept that these were all for scheduling purposes. We also had your Honor's order, not just for the communications, which are not a complete or a fair production.
Let me pause for a second. He says, I find it difficult to accept that these were not all for just scheduling purposes. What is the standard of proof the judge needs to apply to this scenario to rule against the defense? I'm asking this a legitimate question. Does she have to have beyond reasonable doubt that she believes that, in fact, the defense is hiding something? Or is this, just probable cause? What is the standard she has to meet? And I legitimately do not know.
But there was a order by the court to provide all correspondence, text messages, emails, not just with Attorney Jackson, but with the entire team, including the defendant, Karen Reed. And we have received nothing. This is important because if we look at the first half of ARCA's potential testimony, which is limited to their prior report, we cannot fairly and effectively cross-examine the witnesses until we have the information we're entitled, and that's why I've also asked and suggested that ARCA should be ordered and required to provide that evidence as well so that we can see what is there. It is concerning that there are this many texts, this many phone calls, and the fact that this is totally in contrast to what was represented in the past. So before there's even a thought of ARCA testifying, I think we're entitled to the full discovery that we asked for, the full discovery that the court has ordered. I don't see anything to do with billing or anything else beyond these text message and phone call logs. I want whatever content is available. I think it's relevant material. It's pursuant to your order, and this is woefully incomplete. Should I dive into the second motion?
Yes.
So I can move quickly. The second motion, part of it is moot in some respects. I won't go through the tortured history of discovery. We've gone through it too many times. We don't have time for it.
This is a new band name. Tortured History of Discovery. I like that.
But inevitably, it is clear that we have played by the rules, met our discovery obligations, and as we stand here now, the defense is proposing new opinions, new testing, and they don't even have the parts of that testing yet. This is 2 weeks into trial after we picked a jury. This is, at the time of the opening, it is ambush. It is unfair, and we have no ability at this point to reconcile or deal with new opinions and new information. Importantly, the defense's position is they may or may not have a report by May 1st. Our expert will be testifying somewhere at the beginning or middle of May.
Okay, so stop. This report, it's not coming in May 1st. It's coming in May 7th, which is Wednesday. Wednesday, we get the ARCA report, or at least defense gets the ARCA report, and they're going to turn it over as soon as they get it.
He is away. He is not available. And so anything we receive at the beginning of May or end of April, we'll have no opportunity to look at, vet, test, reconcile, or even engage in our own testing. This was my concern all the way back in November. I'm not Nostradamus, but this obviously was something that worried me that actually occurred. And so at this point, it would be fundamentally unfair for the defense to get a benefit for failing to comply with discovery orders by waiting until February to seek permission with ARCA. They could have called any expert, asked for any expert they wanted. They didn't. They chose this method, and this is the consequence of it. And at some point, the defense has to bear the burden of their decisions. We will not have the ability to rush through, have Dr. Brentula come in days before his testimony, try to reconcile, be inadequate. I've had a brief correspondence with him. It's simply impossible. That's why we suggested, although we certainly didn't want to move the trial date, that was the only remedy if the court was going to allow any new opinions, evidence. I say to the court that they should not be allowed to offer absolutely anything new, not only because they missed the discovery deadline. That's technical, but the reality is we're all trial lawyers. We've all tried a lot of cases. It would be a disadvantage, fundamentally unfair, and because of their own choosing. And so anything new we will not be able to reconcile. We would not be able to proceed with our expert in a fair manner. Thank you.
So his argument here, his motion, is only to exclude anything new from ARCA. And this motion stands until he speaks to it again right before the judge makes a ruling, basically in 24 hours from this moment. So this was what, day one? No, not 24 hours. It's going to be. It was yesterday, day before yesterday. All the days are rushed together. It was Tuesday. Monday evening? Was it Monday evening she made the report? I think it was Monday or maybe Tuesday afternoon, the last thing of the day. Tuesday afternoon. I'm going to stick with that. Final answer. But his motion changes between now and Tuesday when she makes his ruling. He speaks one last time. Mr. Alessi speaks extremely briefly, and she makes her ruling. We saw that together. And between the time, his motion will expand from we don't want any new information from ARCA to we don't want ARCA, period. But Mr. Alessi is going to respond here and get fired up.
Okay. Mr. Alessi, is this you? I'm going to ask you to be as brief as you can be, please.
Your Honor, I understand your request to be as brief as possible, but this is the first opportunity the defense has had to respond to almost every allegation that's been made. We haven't had an opportunity, so I certainly respect the court and what the court's request is, but it is going to take a bit of time to put facts out. And I want to separate two categories that the Commonwealth has conflated. The Commonwealth has conflated the issue of what text messages exist, which text messages don't exist, what's been turned over pursuant to orders, and I would like that to be clear to the court factually, because the Commonwealth has misstated just now 3 times the facts.
So I asked this morning, there were 100 or so texts referenced in the exhibit, whatever was presented by you folks. I asked if Mr. Jackson, if he provided them, because my order was clear they would be provided, and he said no. And I asked you at sidebar whether they were deleted, and you said yes, in due course. I have no idea what that means, Mr. Alessi. Why don't you explain that?
Well, thank you for the opportunity to explain it. Here's what it means. Like anybody's phone, those text messages are 2 years old. They don't exist.
So can you also tell me, aren't the ABA guidelines the counsel is supposed to keep everything in a case for 5 or 7 years?
I do not believe that is the ABA rule with regard to experts. I'm unaware of that.
In regard to your client, and this was in regard to your client's case, right?
I'm sorry, Your Honor, I didn't hear you.
Records kept regard to your client's case, which these are experts that were, there's 100 text messages leading up to trial when I was told that by you that there was a pause email and then all of a sudden out of the blue a bill appeared in July. This shows that's not true, Mr. Alessi.
Your Honor, that was a different question that Your Honor asked me back then. That was about emails. That was not about text messages.
Have emails been provided?
Yes, Your Honor.
Okay.
All emails have been provided. And that is why we are in compliance with all orders. And I will say also with regard to text messages, we have provided, pursuant to every order, every single text message that exists. Mr. Brennan just said, I believe there has to be more there. There's not more there, and I don't believe there can be an order of preclusion based upon the speculation of opposing counsel that there must be more. We affirmatively created a document, Your Honor, to be more transparent than the records, where we summarize all of the communications. Yes, we don't have the text of the text messages, but we were completely forthright and set forth every text that was made. Plus, we turned over from Ms. Little, the only other person on the defense team who communicated with ARCA, we turned over her texts and the text of her text messages. There is nothing else in existence to provide, and importantly, the defense was under no order to preserve the text of text messages. And we have never received, as part of discovery in this case from the Commonwealth, any communications between the Commonwealth and its several experts. That has not been what has occurred in this case. But of course, once Your Honor on Friday issued that order to provide everything, we provided everything that we had. The bottom line is, Your Honor, we've turned over absolutely everything we have. And in addition to that, we created a document so that it would be easier. We're the one who showed all of these text messages from Mr. Jackson historically. We created that document. There's no basis for a discovery violation. There's no basis for an order violation. We are in full compliance. So that's the prong one, Your Honor. Prong one is what Mr. Brennan has alleged is incorrect because we turned over, and we did it recently and consistently, we've turned over all emails and Ms. Little's text we provided. There are no text messages in 2024, and there's no order that required those to be preserved, and there is no discovery violation because we can't be in violation of not turning over something that doesn't exist.
All right, go to the second.
Thank you, Your Honor.
Motion.
The second part of the motion, Your Honor, is the most maddening for the defense. And this is the timeline that I can go through very, very quickly. And essentially, what the Commonwealth just argued is we will be so prejudiced that if we get the work that ARCA is underway, working on, that we will be prejudiced because we won't have enough time to address it. Your Honor, the facts show that the timeline for this has been caused by the Commonwealth, not the defense. And I can do it quickly. July 2024, the first trial concludes. November 2024, 4 months later, the Commonwealth decides to retain Aperture. Their decision to wait 4 months to retain an expert, we're the defense. We defend what the Commonwealth alleges. January 30th, 2025, 2 months after that, and 6 months after the first trial, we get an Aperture letter report that's barely discernible about what they've done. It's a 1 page and 1/4 of conclusions and opinions in outline form. Next, January 31, 2025, we get the initial Aperture 140 slide presentation. January 31st, February 5th, we get the case file. In February 19th, we finally get the raw images from Aperture and the scans. That's the first time we get raw images and scans. You can't have an expert work on anything until you even get those raw images and scans. We move, and we have a hearing on March 20, 2025, to preclude Dr. Welcher because the slides are so incoherent and the report is so insubstantial. We can't tell what it is their theory is. So then on March 24th, and at that hearing, the Commonwealth agrees to redact and revise that. So we're already into March 20th. The Commonwealth agrees to redact and revise. Your Honor put the defense on a short leash. We accepted it. And by March 24, we received the PowerPoint that was supposed of the Aperture that was supposed to be have two things happen. It was supposed to be redacted, and there were certain things that were supposed to be changed. What did we get on March 24th? It wasn't redacted, and there were 3 substantive changes to it. The Commonwealth has said twice, including today, there were no substantive changes. There's 3 of them, and to the extent Your Honor wants to hear, I can detail exactly what those changes were.
So why don't you highlight them very quickly, because I
will, Your Honor. I can do it quickly. Thank you for the opportunity. First one, slide 36, they changed the image of 34 Fairview. No small change. 102, they changed the conclusion regarding the time that the tail light was broken. No small change. 123, they changed the image of 34 Fairview. No small change. So we ended up getting those changes, and I want to be clear on the date. That's March 24th. We have a hearing on March 25th. We agreed to provide our response to these revised Aperture documents. Here is the key data point. On March 26th, the defense engages ARCA. Just 2 days after we get the revised PowerPoint with 3 substantive changes. And then we started to respond and provide more information. On March 27th, we responded to the Commonwealth's revised PowerPoint and the Welch report, and then the last 2 items, we renewed our request to preclude Dr. Welcher on Delbert Lanigan grounds. April 1st, and this is another key date, the court decision allowed Dr. Welcher to testify, but also allowed the defense to re-raise objections at trial when Dr. Welcher testified. What does that timeline show? That timeline shows that the Commonwealth took 6 months from the last trial. 6 months, and the defense took merely 2 days after they got the final report of Aperture to retain ARCA. Last point I want to make, Your Honor, is the argument of the Commonwealth that we strategically waited to retain ARCA. Nothing could be further from the truth. As the court knows, and has been the case with this unorthodox situation, ARCA was retained by the U.S. government. They worked pursuant to the U.S. government, and we had to get the permission of the U.S. government to retain ARCA. We moved expeditiously to do that. We got the permission from the government, and as soon as we got the permission from the government, and as soon as we got the final version of Aperture documents, including scans, we put ARCA on it. It has only been since March 24th, not even a month, have we had finally the information from Aperture, which is still inadequate. Our experts still say, with regard to what Aperture did, in some instances, they can't even figure it out because the information is so inadequate. Nonetheless, because of all the considerations we're aware of, we had ARCA proceed forthwith with post-haste. And they are working post-haste, but, Your Honor, we are the defense. That's where I started. We had to understand as best we could what Aperture did. In conclusion, 2 points. No violation whatsoever on text messages, emails, court orders. All complete, robust compliance. And with regard to the allegation that there was something said, that there's some surprise that there were so many text messages, on June 10th, 2024, and I've got the transcript albeit on an electronic device, right in front of me, I just got to get the passcode, Mr. Jackson read a text message right live that he had with ARCA. He read it, and here's what it said. The court, okay. Mr. Lally, so her issue is that she is available this week but not next week, so I really need to get her in on Friday. Mr. Jackson.
Hold on. The court reporter can't hear you. She asked you to stop.
Oh, I'm sorry. My apologies. Am I going too fast? Yes. Thank you.
She
All right.
can't hear you. Oh, it's too fast.
Go ahead. Thank you. My apologies. So, Mr. Lally, so her issue is that she is available this week but not next week, so I really need to get her in on Friday. Mr. Jackson. Dr. Wolf just texted me and said, I presumed you were in court. Give me a call when you're available. The court reporter, I'm getting an interference. Mr. Jackson, I'm so sorry. The court reporter, that's okay. We have been completely transparent that there were text messages, as opposed to emails, text messages about scheduling, about other administrative matters. Mr. Brennan is completely free on cross-examination of ARCA to address every one of his speculations, every one of his suspicions, every one of the ghosts that have been created on this topic. He can address them. If he thinks that we're wrong, we're misstating, he's got the opportunity to speak to ARCA and ask those questions. Your Honor, it is improvident to, based upon speculation, preclude the defense from putting in a defense.
I'm not making a conclusion today regarding precluding the defense.
Okay, all right. What's next?
So I need you to wrap it up because there's something I want to say.
Certainly, Your Honor. I'm going to wrap it up in 10 seconds. There are no violations of any discovery order, no violations of this court's order, and with regard to the retaining of ARCA, because we're the defense, we acted expeditiously in response to the information we're getting, and this can be tested with ARCA, the statement I'm going to make. To this date, ARCA still has trouble understanding what it is that Aperture did and didn't do, which was the reason for my Dalbert Lanigan motion, but we proceeded nonetheless. Happy to entertain responses to any questions.
All right. No, thank you. All right. So as you all know, I previously wanted you to have a seat, Mr. Alessi.
Thank you, Your Honor.
I previously found and believe Mr. Alessi, when he was talking about the rules of professional conduct, did say, I agree, a violation of Rule 14, but not regarding the rules of conduct. At a prior hearing, I found a violation of the defense's reciprocal discovery obligations. It was clear to me, and I found that it was deliberate. This appears to me, contrary to what you've argued, Mr. Alessi, that this is another violation of my order and of the reciprocal discovery violations. We need to figure all of this out before you're allowed to call these witnesses. So I'm going to have a voir dire hearing this Friday. I know we planned on having the view. I need the ARCA witnesses here Friday morning. So we need a voir dire, if you intend to call them, a voir dire on all of this. And I will be sending an order for production of records. I just need to amend it for ARCA to bring all these items with them. So Friday will be for ARCA for a voir dire hearing in the morning. So we'll see you tomorrow for trial, Friday morning for this.
May I inquire briefly for scheduling purposes?
Yes.
In light of the hearing on Friday, will it still be half a day, or are we expected to call witnesses on Friday?
No, it will be, if we could do, Mr. Alessi, how long do you think this voir dire might take?
I don't have an answer for you, Your Honor, right now, because I've got to talk through ARCA and I've got to understand what they have and what they don't have. So I think, in fairness, I think it could take some time.
All right. So no witnesses for Friday, and I think we'll give the jury the day.
And will it be a full day on Thursday?
Yes.
Thank you very much.
Yes. All right, so we'll see you then. I will issue an order hopefully before the close of business today. Jimmy, can you stay and get this out today?
Sure.
Okay. All right, thank
Jimmy's
you.
working late. Judge goes home. All right, that was the summary of day one, and there was a lot that happened. Let's see. Let's go to the edit. This is clip 105. We've got 106. What was 106? Anyway, lots and lots of fun stuff. That was that one. This one comes over here. 106. I want to try to put together a highlights that are a little more concise in this for every witness, and I might try to put this together as we go along and then catch up on the few days that we've missed in between. But for each witness, there have been a few key moments. Obviously, Mr. Nuttall, the first witness, testified, I hit him. That was his key testimony. I think it's also key that he got some things wrong, that he testified differently before, and the puffer jacket, things like that. Those are key moments. But it boils down to 2 or 3 minutes of testimony from him, because he's the strongest witness to testify directly, paying attention, heard her, she said to me, I hit him. So that's why they started with him. But he's not the strongest witness by any means, because he comes with baggage. ARCA was hired for this trial, not for the results of their first report. Right? I think they were sent a bill, though, American Dreamer, after their first testimony. ARCA sent a bill, said, hey, we testified for you. We're going to bill you, and you have to pay. But wait. Having said that, the bill they paid, I think the testimony from the ARCA guy was the phone call they had where he called and they talked about his family and my background. Here's what we do, everything else. I think that's what the bill was, but it was like $20,000. I think they paid for the testimony. But beforehand, there was not an agreement that we knew of. Not new testing, right? The new results that are coming in are, they may have some testing in them, but the new results that are coming in are from the ARCA analysis of the state's expert. So it's basically the ARCA version of what the state's going to testify to. She required that the testing be in BC. The report is delayed. Because the report is delayed. Right. The bill was sent basically after the fact, and it was paid after the fact. Virginia Little, the testimony from both sides is there was no agreement prior to the bill. But it's not like surprise, we're going to hit you with a surprise bill. They did something they normally charge for, but there was no agreement prior to it. $23,000, that sounds about right. Betty, I see what you did with your name there. It's true, ARCA, Mr. Wolf is not paid directly. His salary, he doesn't get paid any more or less for doing this. But ARCA, the company, does make money. Defense was free to hire ARCA if they wanted, but ARCA had a different take on everything. There's no reason the state, the Commonwealth. You can hire whatever expert you want. Usually you only hire the ones that help your case. ARCA fees run over $200,000. For the whole thing, for the feds, I don't doubt that in the slightest. The amount of work they did, I'm sure that was expensive. The bill was for the testimony. Wolf and Ranchler did not bill them. That came from ARCA headquarters. They have nothing to do with the billing. correct. You need a highlight paddle and hold it up during testimony, and I can timestamp. I've got the replay machine. See, I can just spin the wheel and rewind. I'm going to do a better job of using the replay machine going forward. Typically, let me just tell you how I do it. Replay machine sitting right here. If we're watching court, sorry, I'll stop touching the wheel, or I'll just turn the sound off. If we're watching court, I can have the replay machine watching 5 seconds after me. And so if something happens in court, I can just hit the set point of interest and then hit the run button. And as soon as the replay is done, 5 seconds after it ends in court, like the spicy moment, I just hit dump and it goes down to the timeline and it's done. It's that easy to have, and I can rewind and trim and everything else all with keys. I'm going to try to do a better job doing that going forward. I've got the equipment, so I should use it probably. It's a lot of buttons. Can't the prosecution just change the date to later for their expert to give him more time to review the archive? The problem is, Beth, the Commonwealth expert is going to testify first, and then defense gets up, and defense will be pretty quick. Defense is going to be much quicker than prosecution, I think, in this case. And then their guy gets up and testifies, but then on rebuttal, the Commonwealth has another chance to go and counter what the defense presented, and that's what they're worried about. They said, we don't have time. Our expert won't have time to even read the report to prepare any sort of counter. We'll be shorthanded. We'll be cheated out of that opportunity because we don't have time to view that report. Let's see. Ari needs to get us our money's worth out of that machine. It's a nice machine. It's my most expensive keyboard ever. I think this is $700 for this guy. Now it connects to a $3,000 computer and a few, $400 or $500 software, and about $1,500 worth of recorders to make it all work. But the keyboard is what makes it all happen. We use it, Red. I just want to use it more fully. Like we've used it to go back and see. We always use it for the replay. I'm still making a replay sound. If I can get a good sound that's not copyrighted, I need this sound. Ready? I need this one. Maybe I can just record it. It can just be like. I just need that. That gets triggered so that you guys, when you say, I want to hear that on a replay, you can trigger that, and I can just hit the button, and we'd have it, save it in the timeline. Surrey rebuttal is not allowed in Massachusetts. Okay, so you have prosecution, and then defense, and then the prosecution rebuttal, right? That's the rebuttal is what the prosecution wants. Yeah, I need replay command for sure. With that being said, we can do a little bit of court hopping if you guys are interested, but it's a no trial day today. We'll be back tomorrow with more. 9 o'clock in the morning, court's going to start again. But until then, there's not a lot going on with Karen Reed. Let's see. Why is Lady Gaga on my timeline? Judge Jill Banky is not there. Oh, Judge Dad's is about to come in, I think. Sorry, that's loud. This is live. Judge McNally. Thought they were just going to come in because I saw people walking in, but they were walking away. ARCA was hired to rebut the prosecution's expert in this case. So they're arguing for surrebuttal. ARCA was hired by the defense, which will be put on the defense's case in chief. The rebuttal that the prosecution wants is in their rebuttal phase of trial. They want to rebut the version that ARCA is going to present. Is that right? There's a police chase? What? Jennifer Juniper says, hear ye, hear ye. That would be really good. Hang on. Let's go back to the beginning here. Find hear ye, hear ye. I think that's right here. Let's see.
Hear ye, hear ye, hear ye.
There we go. That's a good one. 3 hear ye's. I can do that. It is said 3 times. I'm going to turn the sound off because Judge McNally has left his bench. Interesting fun fact. I've been very, very jealous of the judge's chair. It is tufted. It is leather. It is overstuffed. And it looks glorious. One time, he got up and got out of his chair, and the chair spun. And the back of his chair is ripped to shreds, like the stuffing is coming out. You can sort of see it in the top right-hand picture. You can see some white fluff out of the back of the chair there. It's destroyed. I don't know what he's been reclining against, maybe the corner of his desk or something. It is absolutely just pulverized. Probably very expensive. Oh, it's probably like a $900 chair. But it probably feels great still sitting on it, but the back has seen better days for sure. This trial is brought to you by the number 3. Yes, it is. Chloe got to the chair? Maybe. Maybe he's got a cat or something. Got people coming in, so it should be pretty quick that the judge returns. He normally only takes like a 5-minute break. So, where's this police chase? What channel are you seeing it on? Where's it at? Live police chase. Let's see. I see another channel is running it. I need it straight from the source. Oh, KTLA 5 has it. KTLA 5. I'm not seeing KTLA as being live right now. I think Live Police Chase, the channel is showing it, but it's not live. Which sort of means it's a misnomer. Sky 5 LA. Sky 5 LA. Sky 5, Los Angeles. There we go. Took forever to find it. It's on 8.
Can we zoom in on the rear window of the vehicle? Because it looks as if, I wonder if they're using less than lethal trying to get...
Oh, yeah, we're going to be monetized.
It's a reflection of the trees. Okay, I apologize.
Exactly.
It looked like those...
Is that Stu's voice I hear?
There's a truck in front of him, though. There's something behind the tree. If we can drift a little bit to the east. I know you got 5 there, but go around him. There's a truck there, and it looks like the suspect may not be able to go any further. And we haven't seen them in a situation there was a standoff long enough for them to use less than lethal and try and bust out the window. But you can tell maybe that's a cement truck or a semi of some type, a work truck in this
ABC
area.
Roofing.
It's unclear. It looks like a moving
Shingle
truck
delivery.
or a movie truck with that boom on there. It's unclear whether or not they're there because they want to block the suspect and they saw it coming. I've seen that happen before. Or if that individual is trying to back up into someone's driveway and they're doing some work in the area. But now we have the standoff, and it looks like the suspect cannot continue. We don't believe that it's getting out of his vehicle. Is that what I'm seeing right there?
Yes.
Is that something in his hand? Could that be a weapon?
Nope.
Nothing in his hand.
There's nothing in his hands.
Well, it was odd. He had his hands out of the vehicle, and the vehicle lurched forward a bit. So I don't know if he actually had put it in park, but now it does appear as if he's fully surrendering and starting to comply.
Yeah. Exactly. They'll want him to
walk the wrong way.
Walk back towards the officers. I'm a little curious why he's walking forward. That usually is not the procedure that the officers will be telling him to do. They want him to turn around. They want him to lift up his jacket or his sweater so they can check his waistband. But now it does appear that
he's just proning out, and he gets to sun himself.
Once he's sprawled out like that, they can just rush in and take him into custody. So we don't believe anybody was hurt, Philip. That's the good news. It lasted maybe about 15 minutes or so.
There's got to be somebody else in the car.
At any moment now, they're going to move in and take that man into custody. They are always concerned about whether or not there's more people in the vehicle. So they may run up to the vehicle. They may clear the vehicle first just for the...
This is crazy. Why they wouldn't have him walk back to them is crazy.
Of one of the officers, he had kind of taken matters in his own hands, putting his hands
lady's just walking down the street with a stroller.
To
their
stretch
kid.
out, spread eagle
as
he was had his hands behind his back there. So
Stacks
now
moving
they are going to
forward,
move
clearing
forward,
the car.
clear the vehicle. I would assume they'd probably also want to make sure that the vehicle is safe and not ready to, need to be in park and
Watch
safe
the hand up
for everyone else. And this person, you're not to comply. They would want him to open the door and get out. I can't imagine they would want him to crawl out the window. So he was not doing exactly what they want. So they're still going to be abundantly cautious to get this person into custody. But it does appear as if this is going to come to a conclusion as they want. Again, wasn't incredibly reckless, but certainly was
that license plate looks
what you
awfully
want
threatening.
Because he didn't pull over, he didn't stop, and he did run through an intersection against the light. So it does look, Scott, like we're going to have this person in custody, and this is going to come to a conclusion. And it doesn't look, one last thing, Scott, it doesn't look like this is going to be a big impact on the commute, does it?
Not in this neighborhood.
I mean, there's a couple of small surface streets in this neighborhood of Hollywood that'll be affected, but you could get around it unless you're in one of those homes. You might be locked in for a bit.
Hollywood.
In custody, they should wrap this up pretty quickly, Philip.
Okay. Scott, thank you very much. We just wanted to make sure everybody knew what was going on, and we are going to return you to programming now.
All right, which means that we lose it out. There you go. There are 9 law enforcements divisible by 3. I think you're onto something. We need to pursue this this number issue. But I don't think it was. I think it was a like one of those push carts for shopping or something like that. But anyway, thank you, Scott. Scott, thank you very much. You're welcome. You're welcome. I do what I can. I do what I can down here. But let's see. We are going to jump back to Judge Dad. Hopefully, Judge Dad is amazing. If you've not seen Judge McNally in action, you're missing out in a big way. Not sure what 5 got on that. I couldn't find 5's live view. Perhaps it was through another media source. Ooh, another channel streaming Judge Fleischer. You got Dolly Talk is streaming Judge Fleischer live. His court went dark a little bit, changed how he streams. We lost his channel directly, but now I think you have to stream it from his Facebook or from his Zoom. This lady in jail is...
Did it give you an invite? No? Let me try again.
There we go.
Okay.
We might have another one from McNally to watch from Josh here in just a second. Give me a second to get it pulled up. It was from yesterday. Last guy on the stream. We're gonna wait, and we're gonna go back to yesterday's McNally.
Let's go on this. People against here. Bring in Mr. Sorrell. People against Gregory Lynn Sorrell, 25W837690A and B. Mr. Sorrell, your name?
You know it by now, Judge. 100 times Gregory L. Sorrell.
I'm Joe Crawford, representing Mr. Sorrell.
Gregory L. Sorrell, you know it by now.
All right, hang on a second. Let's bear down here and get this over with. You're going to plead to. I don't even have a. I don't even have
paperwork again. Man, I've been waiting all day for paperwork.
All right, hang on one second, Mr. Sorrell.
Yeah. I got my buddies and coffee, man. I gotta get back.
Slow down a second. Give me a second, will you please? So you have the police report? Yes, you can. So he's going to plead no contest to attempt R&O. Well, you understand the R&O be dismissed. And counsel, you're telling me that he cannot remember this, correct?
Correct.
It was a lack of memory?
Lack of memory.
If you plead no contest, it has the same effect as a guilty plea. The possible penalties are up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yep.
You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. The right to remain silent. Plead no contest, you're giving up your right to a jury trial. You're giving up your right to everything. Nope. No trial, no cross-examining their witnesses, no bringing in your own witnesses, no using subpoena powers of the court to bring in those witnesses. Do you understand that?
Yes, sir. I got it on the next one. Same cop on the next one. I'm gonna have down here.
You said that I can use the police report to establish a factual basis.
So stipulated.
All right, we'll have that report marked Pickles 1 to the charge attempt, resist, and obstruct an officer. How do you plead, sir?
You plead no contest, Mr. Sorrell?
Yes, no contest.
I've reviewed the report. I'm going to accept the plea. I'm going to dismiss the pedestrian violation. I don't need anybody. I'm going to give you credit for time, sir. If you want to say something, feel free. If you don't, that's fine too. You want to say anything, Mr. Sorrell?
Yeah, I'd like to say, why does your court take so long every time, man?
200 fines, 150 in costs, 75 victim choice fee, $50 justice assessment, $475 or 20 days, credit 20. We're closed. Close the case. Thank you very much. Good luck to you, Mr. Sorrell. Thanks, Mr. Buss. Thanks, Mr. Crawford. Thank you.
Thank you,
Deputy.
I'll be suing that same job, so,
I'll be suing that same cop,
Thank
he
you very
says.
much.
That's a headache in the judge's. Well, that's not a headache when it's in the backside like that. That's the judge. That's who we're waiting for here in court, live. Yes, we wait for him to come back. He wants his punch pass punch so he can get his free drink. Good luck with your bogus lawsuits. It's a butt ache. Who are we listening to? Is this court?
Right.
People in the courtroom were just talking.
I need a case dismissal, so.
You want this case dismissed because it's taken too long? We can hear you. Judge Fleischer's live cam feed. Thank you very much for that. I've got to dig for it. Criminal courts. Is it justice court or criminal court? It takes me to the search page. Criminal. Looking for Fleischer. There he is. Lets me watch, but I have to watch through a computer. I'll use the computer that does our counter for us. See if we can do that. Why does he have a do not record on it? That's new. I'll have to research what he's doing there before I can use that. On Judge Fleischer's court, it's got a do not record watermark. So we'll need to find out what's up. I know he's given permission in the past, but you don't see anything that says do not record. I do. I can show you. If the judge doesn't come back. So look at this in the bottom right hand corner, way down here where the mouse is. Do not record. That's the watch one. I don't want to join a Zoom because then I'm sending a signal to him as well, and they can order you to turn your camera on, and I don't want to do that. Like, do not record snippets and post to Twitter, but live stream with Gucci, says Shelby. Sweet Tat, there's a great debate about this. There's a great debate about the legality of courts guarding their the Fifth Estate. You know, the view of the what happens inside. Let's see if I can join via Zoom on my phone without using my camera. Judge Fleischer. Hang on, I've got a spam call first. Hello? 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 Oh, come on. I'll have to call back. It's probably Mark. I said three hellos, but they still hung up on me, which beeped 3 times as well. All right. Still some banging in the judge's court, waiting for him to get back. Looking at the timestamp, it's 12:05.
Stay seated again, please.
Here we go. This is live.
Okay. Hi, I need to get my recorder down here. Where is, do you have a file?
I gave it to the court officer. Good afternoon, Your Honor.
Just give me 1 second, okay?
Yeah.
She's anxious. Judge needs his paperwork. Ooh, big sigh already. That's a bad look for some of the guys.
Good to have you here, by the way.
You guys are just as busy. I usually do house counsel and the circuit. It's just as busy.
This is your days.
Is it?
Usually Wednesdays and Tuesdays are the bigger days.
Okay.
Do you, she said she gave the file to John. I think he's probably down there. Bobby Melt. Out right for you.
He's right.
Okay, go on record. Come on up, Ms. Patillo. People against Bobby Melton, file number 21F235006. Good morning. Your appearance?
Good morning, Judge Deanna Patillo, P82378 on behalf of Ms. Bobby Melton. Ms. Melton, can you state your full name for the court? Bobby Nicole Melton.
All right, so this is going to be a plea to possession of drug paraphernalia with the understanding that the original charge of controlled substance violation will be dismissed, true?
Correct. Yep.
Is that what you want to do, ma'am?
Yes.
If you plead to that drug paraphernalia, the possible penalties on that are up to 500 fines, 90 days jail. Costs are all those. Do you understand that?
Yes, ma'am. Yes, sir. I mean.
You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial by court or jury, right to question your own witnesses, right to bring in your own, the right to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights. We're not going to have a hearing or a trial. Do you understand that?
Yes, sir.
All right. To the charge possession of drug paraphernalia, how do you plead?
Guilty.
Were you in the city of Flat Rock, County of Wayne, on April 19 of 2021 at 8:10 in the morning on Telegraph near Law?
Yes, sir.
And what did you do? You had possession of some kind of drug paraphernalia, true?
Yes.
What did you have?
A cellophane.
I'm sorry?
A cellophane.
And you used that for what purpose?
Gabapentin.
Okay. Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
And accept your plea. I'm going to dismiss the drug charge.
Thank you.
How old is she?
I just want to get one of my kids, man.
Well, Ms. Melton, listen to me.
Yes, sir.
You live in Flat Rock, right?
Yes.
Do you mind if I ask you why you hadn't been here for 4 years?
I wasn't living in Flat Rock. We just moved back out there a year ago.
All right, where were you living? Tell me you were
Taylor,
living
on the streets.
where?
I was homeless and on the streets. Judge, if I could just add a couple of things. She is employed as seasonal at Honey Baked Ham. She does have a 13-year-old child that she's trying to get back to. she's trying to get her life in order. She has an intake number for Sacred Heart, or a reference number, I apologize, for access to set up her intake interview. So she does realize that there's a problem and she is addressing it.
Is she married? Have a husband, boyfriend, anything?
No, just
Is the father in the child's life? How are you eating? And by the way, who's we moving back to Flat Rock then?
Me and my father. My father.
You live with your father? Where did you live before that?
On the street.
Yeah, I know, but you didn't live on the street for 4 years, right?
On and off, yeah. I go to ChristNet as well. I don't know if you know what that is, in Taylor. I was staying in Taylor. On and off. It's been a long.
What?
It's been a lot. I've been on and off. We lived in Taylor. Me and my father lived in Taylor before this, prior to this.
Well, you just told me you were on the street. I'm not quite getting the whole thing.
So he
How long
me
did you live with your father in Taylor?
How long? I lived in Taylor for 10 years.
Ma'am, you said you just moved to Flat Rock, right?
Like, yes.
You said you were homeless for the last few years, right?
On and off, yeah. I've been jumping from couch to couch. If that.
So basically, you were living in Taylor with your dad before you and your dad moved to Flat Rock. Is that true or false?
Yeah.
Then why are you telling me you were homeless?
Because it's on and off. I'm bouncing from couch to couch. It's almost, I don't know. We just maybe see homeless as different. I don't know. Bouncing from couch to couch, I consider homeless, maybe. I don't know. That's.
What kind of drugs, what other drugs are you into?
Me?
No, the guy behind the door. I'm talking to.
No, I was on methamphetamine.
Meth?
I was, yeah.
And you stopped when you got picked up on this charge and sent to
No.
field with a 4,010% bond, right? Right?
No.
Well, when did you stop?
I've been doing this on and off for quite some time. I've been trying to get some help.
Ma'am, sit up and talk to me. You just got done telling me, and your lawyer just got done telling me that you want to go to treatment.
And that's what I'm doing, yes.
Well, what drugs are you into? Now you're telling me I'm not really into meth anymore. What are you into?
Nothing. I don't want to be into anything anymore. I just want to get right.
Then why would you go into treatment if you're not using drugs anymore? Listen to me. I don't want to hear a bunch of nonsense right now. Please just tell me what you're into and don't lie to me or I'm going to keep you there for the next 3 months.
Okay.
What kind of drugs are you using? Now answer me once and for all truthfully. Are you listening to me or what are you doing?
Are you asking right now? Am I using? Are you asking if I'm actively using or no? Because obviously I'm not. But I was doing meth. I'm not actively using right now.
I know you haven't been for a week because you're in custody. Before that, what were you using?
Meth.
All right. You just got done telling me you weren't using meth. You're really confusing me, and I'm not easily.
I'm sorry. I have severe anxiety. Sorry.
You what?
Severe anxiety. Yeah.
What am I supposed to do with her? You tell me what I'm supposed to do with her. Does she have insurance that would cover her in treatment?
She's indicating yes.
You do?
Yes.
All right, here's what I'm going to do. I'm going to have probation interview you right now. We're going to try to get you into treatment. Problem is you're going to be stuck there a few days until I can sentence you. I'm going to have them do a screening. I'm going to help you. We're going to get you into treatment. But you can't be going back and forth and lying to me like this, okay? What day can I get Ms. Patello here? Am I pronouncing that correctly?
Yeah. You say Usually leave the L slide, but it's up to you.
Yeah, I know. What is it really? I thought, is it Patillo?
Yes,
Okay, that's what I'm sorry.
that's okay.
All right, so we're gonna do this. We're gonna do a screening and assessment with probation. Lisa, when you come over there, have them,
Judge,
tell
they
them.
have a contact over there that they email to.
What's that?
They have a contact over there at the jail that they do screenings through.
Okay, so, but I want them to know that what my plan is to have them find out all the insurance information so I can get her into treatment, okay?
Okay.
Now, what's the earliest day I can sentence with you, Ms. Patillo? I mean, how should I do this, Lisa? She's not here again for a couple of weeks. I don't want to leave this young lady in there.
She'll be here Wednesday for your Brownstown docket.
All right, that's when I'm gonna sentence you. Just relax. We're gonna help you. And we're gonna put this on May. So that's the 7th, right?
Yes.
And we'll do this at 9 o'clock in the morning. Okay, young lady? So just hang in there. We're gonna get you some help. But you can't be giving me the runaround here. You gotta get yourself better. You got a child, right?
Yes. Yes.
I mean, that's enough to live for right there, right?
Absolutely.
All right, we'll see you next week. I promise y'all I'm gonna help you. But you gotta help me help you though. You can't say, oh, this and that, I've gone on that, then.
No, yeah.
I've heard every story there is. I wish everybody understood that. Good luck. Hunter Cole Lindquist. Thanks.
Thank you, Judge.
24F 241741. Hi there, Mr. Lindquist. Your name? You posted your bond, right?
Yeah.
Is it in your name? Yes, it is. Why'd you play fugitive on this like this? Why don't you come in and talk to us?
I don't live around here.
Where do you live?
Toledo.
All right. Well, it's not that far. It's 40 minutes, and you could have zoomed.
It's like an hour.
All right. You could have zoomed. You can't ignore courts. When you were here getting your ticket, you got here though, did you? Back in March of 24. What were you doing here then? Tell me.
I was just riding around.
Riding around. You can ride around from Toledo to Flat Rock back in March of 24, but all of a sudden when you got to get to court, you make it sound like you're driving to...
I just don't go up here often. I kind of forgot about it.
Kind of forgot about it. Title of my book? What's it going to be, John? Don't tell the judge I forgot.
Right.
I'm going to give you... Lisa, we're going to go ahead and apply the bond.
Title of my book.
Apply bond. Case closed. Okay?
Okay.
Listen, your record seems thick. I'm not going to look at it now. Seems like there's a lot going on here.
It's not too bad.
Sometimes people's definition of it's not too bad is a lot different than my interpretation of what it's not too bad means.
Nothing in Wayne County.
Nothing. Think I'm supposed to feel better that you got it in Monroe or in Ohio or in Oakland or Macomb? Good luck. Go sign your bond over. Take care. England. Christopher William England. Is this yours? 25F255471A and B.
Right to the podium.
Mr. England.
Sorry about that, Judge.
You're all right.
I'm a little nervous. I haven't been in court in a while. It's been years.
Years? You're only 27, right? 26? 27?
Yeah. 27, sir.
Like I would say I've never been in court. I'm 66. If I hadn't been there since 1981.
Last time I was in court, I believe I was like 16. If I'm being honest.
Okay.
11 years.
All right, just relax. Take a deep breath. You want a lawyer here? I'm going to give you a lawyer. You got a domestic violence and an assault case.
Yes.
Hang on. I'm going to give you a lawyer. Okay? Just relax. You're going to make me have a heart attack worrying about you having a heart attack. Just settle down. Go out in the hall. We'll set you up with a lawyer and we'll take care of this, okay?
Yes, sir.
Good luck. Quincy Lamont Roan Gibbs. Which one do you have it on? Oh, Johnson?
I have Johnson, Judge, and then I also have...
24T641166A. Come on up here, Mr. Gibbs. I'm going to take Johnson next, and you tell us what else we got. Sir, your name?
Quincy Gibbs.
What's going on, Mr. Gibbs?
I just finished up all the requirements for the case that I had, and I was
applying for early release.
This was a jury trial.
Yes,
You lost.
yes.
This was back in June of 24. Let's see, what case was this? This might be the last one I've had. All right. All right. Let's see. Thomas Schulte here. The victim didn't show up. You staying out of trouble?
Absolutely.
Have you been in any trouble since this case? Who was your lawyer again on this?
I had two different lawyers. It was Reese Davis, and it was my last one. His name slipped my mind.
All right, anyway, I'm gonna grant you early discharge. It looks like you've done everything. She sent out the notice, victim didn't show up. You're good. You're granted early discharge. We'll send you the probation order, okay?
Yes, sir.
Good luck. Stay out of here now.
Absolutely.
Johnson. People against. Dwight Stephen Johnson, 23T 640-475 A and B. Your name, sir?
Dwight Johnson.
All right, so this is a suspend?
Yes, Judge. I believe it's suspended improperly.
And he's going to plead guilty to what?
He's going to plead to.
It's got allowing unlicensed driver to drive and drive while suspended. That's what it says.
I believe it should have been.
That might be, but I got to get him to clarify it. Take this over real quick, John. I'm on my court officer running around. He didn't address the improper plate, so just tell me he needs to address the improper plate.
Okay, this is gonna go to.
Or I'll tell you what, let me just call Mr. Cayley in here. Let's make this a little easier.
Judge, that's a Trenton case.
Oh, geez.
With a crossover.
All right. I need Trenton. Where's Trenton at? Here, I got him. 236.
Yes.
Is this Bologna?
Yes.
Yeah.
Tony, Herman, are you going out in the hall?
Me?
Are we in here?
He's just letting me know something.
Well, I know. I was just going to have him take the file to Trenton. I get all these extensions in.
No one answers their phone.
Why are they not answering their phones?
Judge, I believe he may be in Judge Jackson's court.
All right.
It's always this chaotic in his court. Why are they not answering their phones? It's the judge calling. Answer your phone. Josh, I can't find that clip when you just sent me. I have to be able to open it up.
Johnson, we have to clear this up.
Apple TV.
Okay.
It's out for now.
Yeah.
Hey, all right.
No problem.
Judge, I've got 3 ready.
3 ready? People against. Rodriguez. Jalissa Maria Rodriguez, 25R 514-085 A and B.
Good morning, Judge. Resignation here on behalf of Ms. Rodriguez.
Ma'am, step up here, state your name.
Jalissa Rodriguez.
All right, so I have an A file, and I have a B file, and I also, I think, have a C file. Yes, so I've got an expired plate, no insurance, and operating while intoxicated for purposes of arraignment on the misdemeanor. There's just being mute, wait for Maria. I'll enter a not guilty plea on that. Now, as I understand it, she's going to plead guilty to the charge of operating while visibly impaired, the OWI to be dismissed, and they are then going to dismiss the operating while intoxicated, the no insurance, and the expired plate, correct?
Correct.
Is that what you want to do, ma'am?
Yes.
If you plead to that, the possible penalties are up to $300 in fines, 93 days jail, 360 hours community service, court costs, or all of those. 4 points, license suspension or revocation in accordance with your record. Your vehicle could be or might have to be immobilized depending upon your record. You understand that?
Yes, sir.
All right, to the charge, operating while impaired. How do you plead?
Guilty.
And you read all your rights, correct?
Yes.
And you understood them?
Yes.
All right. Again, top rating while impaired, how do you plead?
Guilty.
On April 5 of 25 at 3:43 in the morning, were you operating a motor vehicle on Fort near Huron River Drive in the city of Rockwood?
Yes, Your Honor.
Did you drink alcohol prior to that? And if so, what did you drink and how much?
Yes, I was drinking vodka.
How much?
Too much.
Wine, but what were you drinking? Straight?
No, mixed.
With what?
Cranberry juice.
How many of those did you have?
Probably like 6.
6 vodka cranberries? Is that fair?
Yes, Your Honor.
Are you on probation or parole?
No.
Why were you pulled over by the police?
I pulled into the 7-Eleven, then I pulled out. I might have swerved, and that's when they came.
Do you think you swerved?
Yes, Your Honor.
You think you did that in part because of your alcohol consumption?
Yes, Your Honor.
And counsel, did she take a breathalyzer or a blood?
She took a breathalyzer.
And was the result .14?
Yes, sir.
You stipulate to that for purposes of the plea?
We do.
Ma'am, are you on probation or parole?
Nearly double the
Anybody
limit.
force you to plead guilty?
No,
Ever been in trouble before?
No, Your
No drunk drivings before?
No, Your Honor.
I'll accept your plea to operating while impaired, dismiss the OWI, dismiss the no proof insurance, dismiss the expired plate, refer you for a screening and assessment. I'm gonna give you $1,000 personal bond, no alcohol, no marijuana, no illegal drugs, no alcohol, no marijuana, no illegal drugs. And you are how old?
34.
You got warrants.
I was just informed. I didn't know that.
You got a warrant, 1, 2,
We counted it. Maybe
3, 4, 5, 6, 7 warrants out of Detroit. Why would you do that?
I didn't even know I had those. I thought they were.
You thought they gave you the tickets and they just threw them in the garbage, right?
When I was able to get my license, I
Yeah.
thought everything was.
Go over and take care of those
I
before
am.
you come back, okay? No alcohol, no illegal drugs, no marijuana. You're only 35. I'm gonna not make you do AA right now. Lisa, what do we have for a sentence date with Mr. Gaith?
May 15th at 8:30.
May 15th at 8:30, okay, young lady? Sure.
If the court requires Mr. Rodriguez to clear out those warrants, I think we may need one.
Nah, she's gonna go over there tomorrow. She's gonna go over there tomorrow, May 15th at 8:30. It will be your sentence date. Go down the hall, get your notice, go over to probation, fill out a questionnaire and be interviewed, okay? Good luck, thank you. Moore, Johnny Ray Moore.
The warrants are for tickets.
243-073.
Good morning, Judge. Nice to get to you, Mr. Moore.
Mr. Moore, your name?
Johnny Ray Moore.
How you doing, Mr. Moore?
Tiger.
You a Tigers fan?
Yes, I am. Used to play baseball.
Where?
Here before high school, shortstop.
Okay.
Just tired. I got off work, came straight.
Where do you work?
I work at a dispensary in Southwest Detroit called Moses Roses. I'm the security there from 5 o'clock until 8 o'clock in the morning.
Okay. If you'd worked harder at baseball, you'd be making $7 million a year if you were hitting 210, right? Huh?
Lumineo.
I'm just kidding you. All right, you're going to plead to allowing an unlicensed driver to drive, the suspend to be dismissed, right?
Yes, sir.
If you do that, the possible penalties are up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and there will be no hearing or trial. Do you understand that?
Yes,
To the charge of allowing an unlicensed driver to drive, how do you plead?
Yes.
Were you in control of a motor vehicle on November 13 of 24, 2008 Chevy that was being operated on Gibraltar near Walnut Creek Drive in Flat Rock?
Yes, sir.
Did you allow somebody to drive that was unlicensed and that somebody was you, true?
Yes.
You on probation or parole?
Yes, sir.
Anybody force you to plead guilty?
No.
He's not licensed at all, right?
He was living in a different state, Judge. So he's in the process of living in.
You gotta you gotta move quicker on this stuff, right? I'll accept the plea, dismiss the suspend. You can't drive without a license. Why are you doing that? How long have you lived here?
I'm from here, then I moved out of state. My dad has dementia, so I came back home. I had to get legal birth certificate with my father and my mother, so I moved out to Newport, so I had to find somewhere for them to live. So found a nice house, moved out there. I went down to the city, a friend of mine, he was like, hey man, me and my mama got in, so he can pick me up, take him over to his mom's house. So I'm driving back on 75. I'm not from out here, so I'm not really familiar. Only thing, when I take 75.
So your friend asked you to drive?
Yeah.
Your friend knew you didn't have a vehicle or a license? right?
I'm gonna say associate because he really didn't care. He just wanted to,
Yeah.
man, I'll give you $100 for some gas. I just said, all right, cool.
Well, this could be an expensive ride.
I mean, I had a Chevy Avalanche, so the gas was expensive.
No, but I mean, this is gonna be expensive. If you wouldn't have driven, you wouldn't have to worry about paying this, right?
Right, yes, sir.
Come on, use your head, get a license. You can't do this.
I actually got an appointment with Secretary of State on May 12th.
Anything else?
Nothing else, Judge, just that what Mr. Moore said. He's in the process of taking care of the situation so he doesn't have to have a repeat.
Anything else? 100 fines, 110 costs, 75 victim's rights, $50 justice assessment, 40 in attorney fees. Okay, so it's just gonna be $375 or 60 days. Can you pay that now?
Yes, sir.
All right, it's kind of light given the fact you don't even have a license, but I'm gonna live with it. You're gonna stop doing this, right?
Yes, sir.
Go down the hall, take care of it. Good luck. Romero, file 19F230-998A, B, and C.
Good morning, Judge, and I'm here with Karen back, Mr. Romero.
Mr. Romero, your name?
Good morning. My name is Ramiro Romero.
He's going to plead on the he's going to plead on the unregistered vehicle to defective equipment. He's in default on the no insurance. And then he's going to plead to expired plate, and they're going to dismiss all the rest of these, right? I mean, the misdemeanors he's going to dismiss of improper plate and driving an unregistered vehicle, right? Is that what you want to do?
It is.
If you plead to expired plate, that's 0 points. You plead to defective equipment, that's 0 points. And then you have to pay today the charge of $327 on your no insurance. You're going to be able to do that, right?
I have about $200 I can pay onto it today.
To the charge expired plate, how do you plead, responsible or not responsible?
Responsible.
To the charge defective equipment, responsible or not responsible?
Responsible.
I'll accept those pleas.
All right, he's going to accept the
He
pleas.
agrees he owes the money, right?
Absolutely, Judge.
Give him a light sentence, because that's what he's doing today.
I mean, I really don't need you to say anything, but I'll let you say anything if you want to say anything, Mr. Yates, about these others.
Just that, Judge, that Mr. Romero understands that this is an obligation he needs to take care of. Obviously, they've been outstanding for quite some time. Fact is, the reason that he's taking so long to take care of these, it was financial. Now he's in a better position to be able to take care of these and close these files out, Judge.
Can't do this. Why are you doing this?
Like I said last time, Judge, if I had an excuse, I would.
All right, where do you work at?
Right now, I'm a high scale climber for concerts and festivals.
You're what?
A high scale climber. If you've ever been to a concert or a festival, we put up the stages and I'm the guy up 80, 90 feet in the air.
Well, that's not good.
I like it.
Pays good.
It's fun. And it's the on season right now, so I'm about to make a lot of money to get this stuff off.
It's a good way to look at it. On the no insurance, you owe $327. That includes your clearance fee. You pay $200 now. I'll reduce the balance to 75. So total will be 75. Well, no, that's okay. Let's see. Reduce balance to 50. So total fines, costs, Lisa, will be $250. But you still have to pay the clearance fee. So you pay the $200 now, and then you have to pay the clearance fee. When can you pay the other $95?
I can pay the other 95 on Friday next week. As soon as my check.
All right, pay that by May the 9th.
Hey, Colleen,
So you pay 200 today. Hang on. You're going to pay 200 now, and you're going to pay 45 next week, which will include your clearance. Okay? She'll explain. You can go on 33court.com. She'll tell you all that. You pay $135 on the on the defective equipment, and you pay $135 on the expired plate. And I'm simply going to make both of those due by May the 23rd. Can you do that?
I can.
If you need more time, call the court. We'll go on Zoom. I'll give you an extension. I don't care how many times we got to do that, okay? I wish you well. Good luck. Thank you very much. Have a good day.
Thanks.
Okay, so hold tight. Colleen, do I have your permission to show your channel really quickly? Itchy Withers Horse Rescue. Your live stream? Sure, okay. Awesome. Horsies! This is Colleen, Itchy Withers Horse Rescue. She's got a live stream going up of the horses and the beautiful little cabin on the hill. The leaves are budding. Do we have sound? I'm not sure. I think this is audio, is video only. But Couple horsies. If you want to watch some horsies, there's that. I see you have 70, now 71 subscribers. I just subscribed. And 2 people are watching it right now. Let me see if I can share a link to this. If you like horses, I'm a big fan of animal live streams, because there are some days where you just want to, just relax a little bit, and there's nothing like just having an animal just doing its thing in the background. So link right there in chat. That will get you to Colleen Withers' Itchy Withers Horse Rescue page. I think the picture looks great. I know the eViz is a security type camera. It's an outdoor security camera. I've used some of them in the past. If you're having issues with it, let me know as far as getting your live stream up and running and everything. I don't know if they have audio built in. Anyway, it's a beautiful little cabin. I was drawn to that. A little Lincoln log cabin, interlocking logs. Looks great. So thanks for letting us visit a little bit. We might pop in again. All right, and you might have a couple more subscribers now. Like over 100. Yay! So I see Red was first in chat as well. All right, we're gonna go to lunch. I think. Josh has sent me a couple that I'm trying to play right now, and it's just not working very well for some reason. Judge Shaw. I'm struggling to find it. I need to play it on the Apple TV. I can get it on my phone, but I can't get it to my Apple TV. So I will, I'll check it out. We're going to take a lunch break. I'm going to go check the electrical work that my 2 boys have done and make sure it's good. Probably see if we can, I don't want to shut off the power till tonight because it takes so long to reset up everything. I have to kill the power to the whole house when we wire that, because it's no bueno. I don't like getting shocked is what it is. I'm a wuss when it comes to electricity. I hate that bzzz feeling because it might be the last one you ever feel, and I don't want that to be me. So anyway, so we're going to take lunch, and then we'll see if we can come back for a little bit of court hopping. I don't have any more of Karen Reed highlights prepped yet, but I do have all the video from all of the days of court saved. So if there's something that we want to watch specifically, or somebody has a question about, we can go to it, we can find it, and I'm gonna have to tag them with the days they are. But that'll be great. That'll be great. I'm not gonna take the rest of the day off. I have something to do this afternoon, but we're gonna probably work a little bit this afternoon. We'll be back. Let me just say something in chat. There we go. There, I said hi. With that, we'll play a little lunch music. Itchy Withers Horse Rescue says it's going to be feeding time soon for the horses, so you might get to see Indy, Lacey, Lily, Diesel, Brandy, all there on camera to eat at the same time. So we'll keep an eye on that. Tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. Give me a half an hour, 45 minutes. Does that work? And we'll do a little court hopping this afternoon before we return to the Karen Reed trial live tomorrow. We have one more full day tomorrow on Friday. I do have something I need to go to at 5, so I'm not mad that the judge ends the day at 4, because I've got to be in Kinston at 5, and I need to buy a power supply tonight. So, all right, we'll see you in a little bit. There's a podcast tonight as well. Yes, 8 o'clock tonight. Don't miss that either. So that'll be here on this channel. Smart to respect electricity. Had fellow sailor get shocked while in training on radar. He passed 3 days later a heart attack at 22. Oh. Okay, maybe I won't do anything electrically. You guys have a good lunch. We'll see you in a little bit. Bye-bye.